Okay, we're going to get started. I'm going to start by introducing our first panel. Our panel participants are Mr. Eric Voss, Federal Public Defender from Puerto Rico, Mr. Park Nolan Small from the District of South Carolina, Mr. Thomas McNamara, a Federal Public Defender from North Carolina, Eastern District, Mr. Lewis Allen, Federal Public Defender, Middle District of North Carolina, and Michael Caruso, Federal Public Defender, Southern District of Florida. So we'll get started. Mr. Voss, you may make a brief opening statement.
Thank you, Your Honor. First of all, thank you for having me here today. A little nervous. I don't usually testify in panels like this or at hearings. I started my career for 15 years as an assistant federal defender in the districts of Philadelphia or Eastern District of PA and in Maine. I then moved over to the training division at the Defender Services Organization. That gave me the chance to have a tremendous amount of contact with panel members all over the country. In the training division, our primary focus is the panel. We do train federal defenders, but really what we concentrate on is the panel. Not only do we go out and train, but we listen to the panel who calls us every day. We have a 1-800 number, and we get panel attorneys. And that's most of our calls come from that. We also receive a tremendous amount of email from panel members as we initiate contact and do follow-up. And lastly, I'm now the federal defender in Puerto Rico. A huge part of that job, and one that all federal defenders actually love about it, is working with the panel. They come to us daily with their issues, and we help them in any way we can. Sometimes it is as mundane as voucher issues, and sometimes it is complex and deals with cases. I do not do vouchers. I have never done a voucher. And the only time I ever did a voucher was I did something in misdemeanor courts and felonies in the city of Philadelphia, but federal vouchers is not something I deal with. Yet, I have a very good understanding of what they're facing, what the panel is facing, as far as voucher submissions, voucher cuts, and how it impacts upon their practice, and ultimately the representation that they give. And that's where my knowledge basis comes from. And I also looked at the 93 report, and I read through much of the submitted materials that dealt with CJ vouchers and compensation and management of the panel that was submitted in Santa Fe. And there's a thread from 93 to Santa Fe and from what's happening in my district. And that's what I'd like to address with whoever wants to listen, is that I believe that there is a problem, and it comes from how the panel is managed nationally and who manages them. And I strongly urge that management be actually with federal defenders or a like body and not with the court. I believe a federal judge said it was unseemly, and I do believe that having the court manage the panel and reviewing vouchers and deciding how much time should be spent, too much money spent, and so forth, is really something that should not be with the court. I don't think we would ever expect the court to do that with the U.S. Attorney's Office, and nor would they expect us to do it to the U.S. Attorney's Office or to the court. These are three very different groups, and I believe that panel attorneys who are defense attorneys are best managed by the defender organization.
All right. Mr. McNamara.
Judge Cardone, members of the committee, I was the United States Attorney for our district back in the 1970s, and then for 24 years while in private practice I was a panel attorney. And then 16 years ago I was appointed Federal Public Defender for the Eastern District. I think this 50-plus years of service has given me a unique perspective into running the Federal Public Defender Office, and it may have helped me, I think, establish a truly unique relationship between our office and the court. We have an outstanding rapport relationship. I have the support of all the judges. I think I'm fortunate to work in the Fourth Circuit, where we have an outstanding relationship with the judges of the Fourth Circuit also. I think that it's important to have an effective and efficient administration of the Criminal Justice Act to be able to keep this type of a relationship here. Now, I wrote in my submission principally about management of the panel because I really think we have a model to go by for other districts. My office and myself do everything from A to Z. We select the panel attorneys when we have conflicts. We work closely with them to give them advice all the time. We have extensive training sessions for them. We have a listserv, a newsletter rather, that we give to them. I personally write every reasonableness review that goes to the judges, and it's been hundreds and hundreds in the 16 years that I have been there. It's very time-consuming, but I think it's an important relationship to have with the panel attorneys and the court. And luckily, we don't have much voucher cutting in our district because I think the judges respect the district's, the service I have provided to the district. I certainly know what criminal practice is like, as well as prosecution in federal criminal cases. So I think they accept what I tell them that we ought to do or what I recommend in the long run. And I think it helps to have such a strong relationship with the panel. Now, everything I think is positive except one point, as I wrote in my submission. I really think that we ought to be able to be given the right to help the judges selecting experts when the panel applies for experts. That's the one area that the panel members in our district are concerned about. And this is something that's come up more over the last year and a half, I think. The judges either deny them the right to have experts or they don't give them enough funds to really make them as efficient as our office is, because of course we can spend our own money to hire whatever experts we need. And I think it gives a sour taste in the mouth of the panel attorneys that we're funded much better than they are. So that's something that I in my letter, I recommended that I have some input into that. Now, I could very well go to our judges and say, maybe we could work out something and maybe it could be worked out. But I see that as a problem across the country. I've heard other federal defenders say the same thing, so I'm sure I'm not the only one raising that concern. But I think that particularly in the area of psychiatrists and psychologists, our judges seem to think that the panel attorneys don't need them or not need them as much. And I think the panel attorneys are concerned, rightfully so, because we certainly hire a lot of those type experts in our cases. So all in all, I think everything really is going well in our district, and I don't have any complaints, and it's mainly because of the great working relationship that I have with the court. And this is just a personal example, but I plan to retire next year. But one of our district judges told me that I apparently didn't realize I was appointed for life. And I said, no, that's you, Judge, not me. So they're happy with the way I work, and I'm happy to do this job. But it takes a lot of talking back and forth. We have to work together on so many things, and it's not that the judges just leave me alone. I hear from them frequently. We discuss things, we work it out, but I really think they're pleased with the way we're running things in the Eastern District, and I think it's a credit to the Criminal Justice Act. So that's basically my opening. So.
Mr. Allen.
Thank you, Judge Cardone and members of the committee, for allowing me to come and speak to you today. Unlike Mr. McNamara, I am not an Article III defender as much as I would like to be, but I have been the defender for the last 18 years. The Middle District of North Carolina contains the town of Mount Airy, fictionally known as Mayberry, the home of Sheriff Andy Taylor and Deputy Barney Fife. When I began clerking for Chief Judge Eugene Gordon in 1980, we were still trying moonshine cases. and the defendants would frequently walk into court or stumble into court unencumbered by shackles or chains, and I cannot swear that they were allowed to let themselves in and out of the cells by themselves, but it's possible it could have happened. It was a different time back then. But I was so impressed with watching the indigent panel attorneys, we didn't have a defender then, watching the indigent panel attorneys, that I gave up my desire to search title for the rest of my career and stayed in Greensboro. And as quickly as I could, I got on the CJA panel, where I was rewarded with the princely sum of $20 an hour for my work. There weren't too many attorneys on the panel because not too many attorneys could afford to be on the panel. It became a source of stress between my law partners and myself that I stay on the panel because I was losing money every time I took a federal case. But I loved it, and so I continued to take those cases. As a panel attorney, I watched the moonshine cases turn into marijuana conspiracies, and then the cocaine and crack lead to our beloved sentencing guidelines. But every time I came into court, I was quite nervous because we didn't have an office, a defender office in the Middle District. We had no one. And I think this is true throughout much of the country. The CJA panel comes largely from small firms or solo practitioners. And while I appreciate the role that the training division has played in training panel attorneys, and it is much more than it was 20 or 30 years ago. It's much more training. I don't think you can discount the importance of the relationship of the defender office as setting a standard, hopefully with consistent representation, that all the panel members will see, will be able to know personally, will be able to contact and give advice, especially as the federal criminal practice became increasingly far more technical and littered with landmines. I was thrilled in 1997 when my virtually pro bono calling became my livelihood, and I became the defender. And going to the first conferences where the legends of defenderdom, the Terry McCarthy's et al., inspired and taught, it was a rowdy crowd in those days. There's no doubt about that, but there was never an absence of purpose. But as a newbie defender who had been in private practice for more than 15 years, I was horrified when the talk at our early defender conferences turned to timekeeping. There had not been a serious timekeeping effort up to that point in the defender system, and it was just being instituted. And they said it was becoming increasingly necessary that we would need to justify our budgets through data. Well, I had watched as my father's wonderful practice had gone to billable hours. I had sat as a judicial law clerk and watched billable hours drive some of the most wasteful civil litigation that I could imagine. And I spent a decade and a half billing those damnable hours and trying my hardest not to let it influence my decision-making as a lawyer. I screamed repeatedly at these conferences, no, don't do it. Defenders are reactionary. We do as much work as is necessary to respond to the impetus of the prosecution of the U.S. Attorney's Office. Our value can best be judged by our performance, not by our timekeeping skills. I kept saying we should demand to know what is being spent by the Department of Justice on local prosecutions, and a study should be done and our budget should be directly proportional to that amount. To do otherwise introduces a host of evils. It will waste our time, divert our focus, and produce aberrant, if not meaningless, statistics. Unfortunately, not enough folks other than the late, great Frank Dunham had been in private practice and had personal experience in how these data-driven measures can warp the profession. So I became known as the crank from Mayberry who wouldn't shut up about timekeeping. Yet in spite of the introduction of that insidious virus, the Defender program, with the benevolent and appreciated support of the judiciary, continued to thrive. We would hear about Judge Prado's committee and that report at the DSAG meetings in the early 2000s, but I had no historical frame of reference. I was not a defender back then. And from my experience, the program really seemed to be running quite well. Ted Litz would sound repeated warnings about a lack of respect in certain quarters of the AO. But so far as I could tell, the program continued to receive support and to provide remarkable defense across the country. I hate boosterism, but I could honestly believe that the Defender program was the gold standard for indigent defense in the country, if not in the entire world. And then came the demotion, and then came the sequester, and then came the work measurement study. We had known all along that we could not survive without the judiciary in our corner. But in this dark time, we were reminded that the judiciary could exert as much influence and control as it desired over the administration of the indigent defense program. Morale took a very dramatic and noticeable hit across the country. Paychecks took a dramatic hit, even though the sequester certainly was not the doing of the judiciary. And careers were derailed as career defenders and assistant defenders lost their job. Now, that might not startle any passing observer who would note that, well, the Defender program is in the judiciary. But it might startle a law student who had imagined that an arbiter should not be able to exert more control over one side in contested issues than it does in the other. And it was quite obvious to us that the Department of Justice, the consequences that they were suffering during this dark time for us, we couldn't notice them at all. And certainly the judiciary didn't have any effect on that. But wise judges are a large part of the reason Defender program is what it is today. And I believe it will require wise judges to exercise the wisdom and restraint to allow the program to exist with minimal involvement from sitting judges. That is not to say that Defender offices should operate unrestrained with complete control of their funds, and it is only to hope that within the AO, the administrative management be vested as much as possible in non-judge governmental employees who understand the vagaries of establishing personal trust with clients as diverse as the homeless schizophrenic, someone charged with a massive fraud, or even terrorism. In many respects, Mayberry is very similar to the Middle District of North Carolina. We don't have a lot of the issues that are part of the focus of this committee. And our judges are uniformly supportive and restrained in the way they do with our program and with the panel. You will see from the letter that our Chief Judge, William Osteen, submitted that he understands, and he is one of the few judges I know who was previously on the CJA panel. He understands and appreciates the complexity of finding the sweet spot in the delicate relationship between defenders and judges. And I very much appreciate the efforts that this committee is going to try to find that sweet spot. Thank you.
Mr. Carissa.
Thank you, Judge Cardone, and thank you all members of the committee for taking time out of your busy schedules to conduct these important hearings and for having the good sense to have your January hearing in Miami. I'm particularly honored to testify here today because as a first-year law student, my criminal law class was taught by Professor Francis Allen. As you know, I didn't know at the time, but I've since come to learn that Professor Allen chaired the committee that essentially created our federal public defender and CJA programs. And once I learned of Professor Allen's involvement and traced the history of our joint programs through the year, it seems to me, and it's not a tremendous insight, that the issue of defender independence has been simmering for the last 50 years. Throughout all the committees have worked on this issue throughout the years, and certainly the issue came to a head when Judge Prado chaired his committee. And I think in reading the Prado Committee's report from over 20 years ago, the bottom line conclusion was that there was no better entity to protect the defender program than the judiciary. And it seems that conclusion or reasoning drove the result of that committee's work. And while I was not in the program 20 years ago, what I have seen over the last few years, and ironically so because of the Prado Committee's report that we needed more independence, I've actually seen over the last few years an eroding of the little independence that we did have. And I think the erosion of our independence has diminished the program. Whether it has actual effects or perceived effects, Mr. Allen is exactly right. Through the demotion of DSO, through the sequester, through the work measurement study, there has been a perception by many, many people in this program that our programs are under assault. And I think, like the Prado Committee and like Professor Allen did, nearly 50 years ago, this committee does need to seriously address whether there should be a restructuring of our programs, whether that restructuring entails a completely independent agency, or whether that restructuring means that we at least assume the position within the administrative office that we had enjoined prior to the demotion. There certainly are meaningful structural changes that have to take place so we can deliver a better product. Through my written testimony and what I hope to say here today, I don't want anybody to misunderstand that I believe that both the federal public defender offices and the CJA panel attorneys provide an awesome product to indigent defendants. I'm in court nearly every day and have been for the last 20 years. I'm simply awestruck by the work of everyone who's worked in my local federal public defender's office over the last 20 years and the work of our panel members. There is simply not, in my estimation, a better group of people providing indigent defense service to our clients. In addition to the structural issues that I think this committee needs to address, I think the special topics that you identified for this hearing are particularly important, not only to the lawyers and staff members of the Federal Public Defender's Office, but the CJA panel. We do, and again, as Mr. Allen said, we stand in slightly different shoes. The Federal Public Defender's Office has the benefit of an infrastructure both locally and nationally. In this district, we have approximately 170 CJA lawyers. They're primarily solo practitioners. And when you look at the practice of our district, and these are all identified in your special topics, the large multi-defendant cases, the international component, and the e-discovery and the use of experts, all these factors provide a tremendous amount of stress, not only to the assistant federal public defenders, but to the solo practitioner. It is not uncommon in this district to have fraud cases where 3 terabytes of information have been provided to counsel. The internet is a wonderful thing, so you can actually go to the internet and find a terabyte calculator. So when you plug in 3 terabytes of information, what comes out is 6,000 filing cabinets. So you can imagine, even if my office has 2 lawyers, a paralegal, and an investigator assigned to that case, you can imagine the CJA lawyer who's a solo practitioner who has to make sense of 6,000 file cabinets and not have the support staff. That lawyer has to ask the judge for a paralegal and 4 experts. So I think this committee is wise in identifying those topics, because although I'm a believer in data and analytics, that can only tell so much of the story. I mean, you really have to see it from the ground level view of the lawyer who is confronted with one of these cases and forced to handle one of these cases on a very, very limited budget. And what is, I won't say particularly unique to our district, but another aspect of the practice in our district is that we are both a very trial-heavy district and a district that works at an extremely fast pace. So for example, and not only in terms of the mega cases, but I'll give you one recent example where a lot of these factors come into play. My office, lawyers in my office recently tried a case. It was a relatively simple matter. It involved the importation of drugs by a person accused of being a courier. Our client lived in New York, flew to Peru, was arrested here in Miami to stand trial for possession with the intent to distribute an importation. That trial began 46 days after our client's arraignment. And given that limited amount of time and given the circumstances of that case, to adequately conduct a defense or a defense investigation where we needed to conduct an investigation in South America and Peru, where we needed to conduct an investigation in New York where our client lived, we simply could not perform up to our standards with regard to those components of the case and the time that we were given. And that's just one very small example of the stressors that are placed on both the assistants and the CJA lawyers in this district. And I know the committee is going to consider those factors among others, and I look forward to your questions.
Mr. Small.
Judge Cardone, members of the committee, a wise lawyer once told me that no lawyer should be on the witness stand, to stay away. Well, but here I am. There are 3 words I think probably define maybe why we're here. One is quality, the other is independence, and the third is trust. If we go back to the original case of Gideon, we find in that case the court there was interested in having people without a lawyer to have a lawyer to oppose experienced and well-funded government prosecutors. And after all, it was Abe Fortas that represented him at the Supreme Court, and it was the best lawyer in Bay County, Florida, that represented him on retrial and achieved an acquittal. And after that, of course, Congress created the Criminal Justice Act and the present model plan that we're working under. And for many years, that plan has grown and worked and experimented and has become well accepted, I think, throughout the court system as providing the quality and the type of representation that was intended by that original case. We have innovated, we have improved. The program has been repeatedly called upon to represent defendants in cases that we never even thought about when Gideon came along. Terrorists, large financial cases and fraud cases that take tremendous resources that we never even thought about. But the defenders have proven trustworthy and responsible in an independent setting with substantial budgets and decision-making authority. Just as a quick example, when I started some years ago, under the plan, I could get any expert I wanted for $300. Otherwise, I had to go to the district judge or perhaps even to the chief judge of the Court of Appeals to get an expert. And how unusual that would be if we had to do that today, and how much resource and time would we take up of the court system if we had to do that now. But I think that system has worked well because now we have tremendous responsibility to manage these budgets and to manage them in a reasonable and substantial way. The model we have is a tested model. It provides efficiencies and experience based upon an exclusive focus. That is, we spend all of our time every day talking about federal criminal cases. Our partner in this operation is the CJA panel, and they are a group of wonderful people. They don't get to practice as much federal criminal law as we do, but they provide a very essential and substantial service in the representation of cases, particularly in multi-defendant cases. And it is vital that we support this CJA activity and panel activity with everything we possibly can. We need to give them as much training as possible. We need to give them as much support in voucher review as we can. We need to give them as much support in finding experts for their cases as we possibly can. In the District of South Carolina, we have a panel administrator. And I know that's done in some districts, and I don't know how many, but it has worked very well in the District of South Carolina. Panel administrator is revered by the judges and by the panel attorneys. And it is much like an ombudsman. The panel administrator does the first review of vouchers and carries it right on through to the very end. So I think that is one element that I would think that this committee might want to consider as urging as a practice in any other district that would like to participate. The only other comment that I have is, sequester was tough. That hit everybody, and it hit the rest of the government as well as the court system. And it generated some questions. Well, that's okay. Questions should be asked. But the examination that resulted was an examination of the quantitative experience that defenders had. That is, cases per lawyer. And that is only one measure of the effectiveness of our system. The other measure is a quality measure. And that was given less attention. And it is very hard to judge quality. You know it when you see it, but it is hard to judge. But because of sequester and because of the study, there has been a feeling that the Defender program has been reduced in stature. And I would ask this committee to consider that we give more attention to the qualitative part of what defenders do rather than just the quantitative part, because there has to be trust in this system, and there has to be trust of defenders, there has to be trust of CJA panel attorneys for us to produce the quality work that I think we all want and expect in this great system that we have. So I would hope that you would give those things some consideration. Thank you.
All right, Ms. Rowe, question.
Thank you all for being here today. The first question I want to ask is about the issue we've been hearing about, the, if you will, two-tiered system for experts, psychologists, investigators. The federal defenders obviously have staff investigators and some also staff paralegals and sometimes social workers or things of that nature. But the panel attorneys have to actually file a request of the court to be able to get folks to assist them, or psychologists to evaluate their clients. Mr. McNamara, you spoke about in your district, you could see that there was definitely a two-tiered situation also, one of the chief complaints, if you will, of your panel. And I want to ask you a specific question, but then open it up to the whole panel. First, I want to ask you a question about, in your district, the judges see that the federal defender and the assistant federal defenders obviously use experts and fund these experts and have the benefit of these for your clients. So I'm wondering why they think it's so unusual, or they're unwilling to give that same benefit to CJA clients. I'm also, of the panel, I would ask that same question, but also more broadly, whether or not all of you folks think it's a problem in your district, also this potentially two-tiered system where folks who are represented by the Federal Defender's Office have access to experts, but folks who are represented by CJA attorneys have a much more difficult time gaining that access.
Well, one thing, Ms. Rowe, that I have seen in our district, see, we have the Adam Walsh Act cases. We've got probably 95, 98% of all the Adam Walsh Act cases in the Eastern District of North Carolina. Now, we use psychiatrists and psychologists frequently in those cases, and when we've had conflicts, the panel attorneys that are in those cases are able to get those type experts. And I would have thought that that would have carried over to regular felony cases, but it doesn't seem to be. And I don't know quite the distinction there. In fact, one of our panel attorneys just recently raised as an issue in an appeal to the Fourth Circuit that he was denied a psychiatrist that he had requested. And I thought, well, that's bringing it to the forefront, but the Fourth Circuit wasn't impressed by that. Now, it could be that the panel attorneys are just not justifying their need, which they have to do in their ex parte motions that they file. But I just don't understand why in a normal felony case, when we use, for mitigation purposes in particular, we use psychologists and psychiatrists, and the panel can't seem to get them. So I don't know that I have the answer, but I see it as a problem, and I wish there was something that could be done about that. Now, if the judges would just ask me, you know, or some independent person, say, what do you think about this request from the panel to get a certain service provider? I think that would be helpful, but they don't. Now, that slows the system down a little bit, but that's one suggestion that I would have to improve it. Just, we have input into everything else. When the panel attorney gets a service provider, I review those vouchers and bills before they are sent on to the judge, but I had no input into the selection of such a person. So sometimes, now it's different with different judges, but it needs to be more uniform, because I can certainly see where the panel is hurting if they can't provide the same effective representation that we are, because they're denied experts. So I'm not sure I have the real answer, but that's what I see. Now, maybe some of these other gentlemen do.
Ms. Rowe? I just know numerically, our office has 7 full-time investigators. We have mitigation specialists. We have research and writing paralegals. We're spending over $1 million easy, probably closer to $2 million in this support staff, which the panel would have to go to otherwise. I spent $325,000 just in experts, and that was aside from my staff. So you can easily be talking $2.5 million there. The panel in Puerto Rico spent around $100,000, that's what I was told, on third-party experts or professionals. That is a colossal difference. We got a case in where we're going to have a mentally handicapped individual chat room with an alleged 13-year-old who's actually an FBI agent, and I look at that and I'm going to need a psychosexual study. It's going to be $4,000 to $5,000, maybe $6,000. It's going to have to be an IQ study, another $4,000. And when judges start to see those numbers and they know that they're thinking this is a $10,000 or $12,000 case, that causes them to really question why they're going to spend the money. And also, an expert sometimes tells you just where you are. We're attorneys. If you do a lot of these Adam Walsh cases, you may have that, but if a panel attorney doesn't have that, they're not even sure yet where they're going until they talk to an expert. Experts aren't the end game, they're the beginning of the game. But there is no panel member out there, I don't care if it's in Puerto Rico, New York, wherever, who doesn't envy what we have, because we're working these cases the way they should be worked. And the work measurement study, when they studied us in great detail, found out we were doing this actually on the cheap, less expensive than we should have otherwise been spending money on this program. So we're not just throwing money around, we're actually doing it very, very economically and very well. But the panel just does not have those resources, and judges, even if a judge was a defense attorney at one point, what a case looks like today with terabytes, with child pornography, with the internet, with Booker and mitigation, that's not what we were looking at in the 70s or the 80s. It's a whole different ballgame, and so there is a prejudice there in approving these funds. But there is certainly two tiers when you have to start to hire third-party professionals, and there's two tiers outside of that. But I do not want to have to see anybody suffer that, and especially the panel, because we talk about this dichotomy, the panel and the federal defender. We're really one. We suffer each other's prejudices. If a case can't be fought by the defense in that district, we all suffer it. So there's probably a lot of reasons, but the bottom line is the panel is suffering, the defense function is suffering.
Ms. Rowe, I just can't think of another issue that is really much more important, or that much more can actually be accomplished than this. I'm sure the judiciary is as well aware as are the defense lawyers that the criminal justice system has also become the system for dealing with mental illness in the country, as more and more folks out there are unable to get their mental illness dealt with any other way. They run up against the law when they act out, and then they become our clients. And the court sees them when they come before the court, and the court understands how difficult it can make a court proceeding. But as Mr. Voss said, many of the judges who may have been in private practice were probably in private practice before we had so many clients who present themselves with a serious mental illness, and how much more difficult that makes the representation of the client, how much more time it takes, and how much more we need the services of experts. And I think as that has become more and more the case, then we came to the period of the sequester, and real or perceived, it was perhaps at least perceived by many of the panel attorneys that district judges became more concerned with cost containment. And during that period of time, perhaps it took a little more effort for a panel attorney to get a court-appointed expert. And as assertive as criminal defense lawyers can be, it only takes being turned down a couple of times, which may make all the difference in the world in the next case as to whether you make the effort to ask for that expert. If you feel like, well, this particular judge is not going to do it, then perhaps you will not make the effort. As Mr. McNamara talked about, the consistency, where we have remarkable consistency in the Middle District of North Carolina. But if defense attorneys think, well, this judge is not very ready to grant experts, when they have a case before that judge, they just may not make that request. They may not make, it's either these little things that the fate of the defendant rises and falls on whether or not you feel good about doing. I disagree with some of the earlier suggestions that we should take on within our offices all the management of the panel and all these decisions, because I think to some extent that is shifting the potential conflict from one place to another while it's still a potential conflict, as we represent co-defendants or maybe perceived as looking after our budgets at the expense of the CJA budget. And my idyllic view would be that there would be an independent person who is responsible for doing all these things, from CJA voucher review to reviewing experts. Now, ultimately, they may be approved by a judge, but having somebody outside of the litigation itself to review these things and have the same person review it for every case, for every judge. So you would develop that sort of consistency. And then to have that person trained as a defense lawyer, to have that person with defense lawyer experience who has sat in a jail cell trying to get a mentally ill client to understand what is going on and to make decisions that are in his own best interest. I really feel like it should be a requirement that whoever does deal with that is thoroughly steeped in criminal defense work.
Thank you.
Yeah, I would add, I would agree with what Mr. Allen and Mr. Voss said. There definitely is a two-tiered system. You know, whether we have those two tiers because of court denials of appropriate motions for experts, or whether certain panel members are reluctant to ask for experts, or a combination of both, I don't know. In this district, I don't see the vouchers as they're submitted or whether they're when they're passed upon by the court. I mean, what I definitely can say is that the public defender office utilizes experts at a much higher rate. I know that just from being in this district and working on co-defendant cases. And clearly, for all of our practice, mental illness that our clients suffer is a great issue. If you've ever had to sit in a jail cell with a person who's schizophrenic or bipolar or even has ADD and try to explain a plea or the consequences of allocuting at sentence, or a host of other factors that are involved in the processing of a criminal case, you know, it's extremely difficult. And even if you think you've left that jail cell with an understanding that your client is prepared to go forward, you're often confronted at your next visit by starting off at square one. So that's one issue, and that's present, I think, in all of our practices. The other aspect is the changing complexity of the federal criminal case in this district and most other districts. And, you know, and I point to one thing in particular. We have a very, very high incident of fraud cases here, and the cost of forensic accounting, which I think is critical in all of those cases. When I see those expert requests in my office, I see in the subject line forensic accountant, like I go get a cup of coffee because I know that, you know, this is going to give me a headache. And I think where the Defender program is in much better shape is that we do have a certain amount of bargaining power. So I personally approve all the expert requests. So if we have a roster of 6 to 8 forensic accountants, they know this is not the only case where we're going to seek to employ them. And that's built into their rate. They also know that we don't give them every case because, you know, that's not the appropriate way to go. And when I look at the CJA lawyer, who again, mostly overwhelmingly solo practitioners, they don't have that bargaining power. And they know that the judge is going to get a sticker shock, because even if you're talking about a relatively mine-run case, the amount of documents and the document review that has to be done either to get the AUSA to agree to a loss figure or prepare to persuade the district court judge at sentencing to a loss figure, the costs quickly add up. So I'm in agreement that the vouchering process, and in particular with regard to experts, be divested from the court and given to an independent administrator, whether that administrator is housed within the Federal Public Defender's Office or in some other aspect to avoid the conflicts that I think can be managed quite easily. I think that would have a number of beneficial effects. One, I think there would be a greater use and a greater willingness for CJA lawyers to request expert services. But I also think it would be part of a cost containment strategy in that if those experts requests are funneled through a single administrator, then that administrator on behalf of the CJA could achieve some of the bargaining power that the FPDs have.
Well, in South Carolina, in the audience, there are 2 panel members here today, and I can assure you they are not shrinking violets. When they want something, they ask for it. But I think as a general proposition that maybe panel attorneys are often maybe a little bit more hesitant or don't know that they need an expert or what kind of expert they need or how to use that expert or where to find that expert, which another example is like maybe in a drug case where the DEA has been following everybody through cell towers is where do you find a cell tower expert and how do you use him and what's the value? So, it's a matter of training and education. We make ourselves available as possible. In fact, we're available all the time to the panel whenever they want to call and whatever they want to ask. But how to resolve that problem of putting it in an independent context so that the judges don't have to be bothered with making those decisions. To me, I think that would be a great benefit, just not to have to bother with it and let somebody else decide.
All right, let's move on. Judge Goldberg.
Thank you all for your incredibly thoughtful input. The wisdom and experience of the 5 of you, I wish I would have a lot of questions I could spend today and tomorrow just asking you questions. And Mr. McNamara, congratulations on 50 years in retirement. Is it 50 years in criminal practice? Those are like dog years. It's a lot. Congratulations to you.
Thank you.
I want to shift the conversation, if I can, to independence, defender and CJA independence. I think each of you wrote a little bit about that and spoke a little bit about that. And so we've discussed it a lot privately in our first hearing and in other meetings that we've had. It's the spectrum. I think Mr. Allen said our goal was to hit the sweet spot. Where is enough independence and where's there too much and where's there not enough? So one extreme, we've heard from one end is the system is fine the way it is and the defender services, the defender offices and the CJA lawyers are fine under the umbrella of the court and it should stay that way. And the other extreme we've heard, I'm not saying extreme that these are unreasonable positions, I'm saying one or the other, is that it should be complete and total independence. There should be no connection whatsoever to the judiciary. So my question for all of you, and whoever wants to speak first, I'm fine to hear from all of you in whatever order, is if you really, really thought through what that means as far as funding from Congress. And so I'm not wearing a robe today. I can talk about politics a little bit. And I wonder, I don't have any experience in what it would be like to go to Congress, hat in hand, and say, I need funding for my programs. I have never had an interest in being a lobbyist, if that's what it is. I don't know if you folks ever did, but I think that that's those persons who advocate for complete and total independence should think that through and maybe tell us whether that's something you really want. If you had Congressman Fisher and Congressman Walton and Congressman Prado here, we'd say we 100% get the importance of indigent representation. Tell us what you need and we're here for you. But we could probably all agree that there are members of Congress who may not be so reasonable and may be thinking about politics and re-election before, as they make decisions on how they're going to fund people who represent criminals. So I'd like you all to comment on the perils of that, and is that something that the Defender Society and community really wants to do?
Well, I'll be glad to speak first because I may be one that's against 100% independence. Just what you say, Judge, I don't see how we're going to lobby for funding by ourselves. Now, I know that a lot of defenders don't agree with me, but I've been in the system long enough to be satisfied principally with what I see there. And that's in the beginning. If you cannot get your money, you really are hurting. So I think that stops it for me there. Now, I have been very pleased with being selected by the Fourth Circuit and working with the Fourth Circuit. I always thought that's been an excellent relationship for my 16 years, but I do think that there are certain parts of what's been going on that needs to be changed. Now, I think demoting Defender Services was a mistake. I think that should be elevated to the former status. And there are certain things, but I'm not in favor of total, and I think there's got to be other defenders like me that are just not in favor of trying to get out there and round up our own money, because that's terrible. I'm not a lobbyist, and I don't know who among the federal defenders are. Now, I guess
Now we know what Mr. McNamara's not going to do in retirement. Not going to be your lobbyist.
That's right. Now, maybe I'm speaking because I am retiring, but I know a lot of defenders are in favor of that, and maybe we should see what these other panel members say.
We've heard that from very smart, reasonable people. Say total, complete, independence. So,
I've heard it too, and I'm surprised, quite frankly. But let's see what these folks have to say.
I think that voice of total independence comes from a level of frustration. It comes from the demotion frustration. It comes from this wide understanding that we were targeted for cost containment, which was just really another word for cutting. And I don't think there's, I hear what the politics have to say about federal judges and the judiciary. Not big fans of theirs. I mean, they're liberal. I wish I had that bench all the time. What the politicians have to say about the judges is scathing. Like they're a bunch of, hippies. That's what it sounds like sometimes. So that, I don't think there's a lot of friends there, but in the realm of things, we're talking about, I think it was 0.2% was the judiciary, and we're 1/7 of that. So we're even a smaller sliver. When we go asking or begging for money, we're not asking for a lot. And I think that we've shown ourselves to be excellent stewards of the money that we had. Our results are the gold standard. So I'm not that scared of the independence. I think that there's an in-between model which they talk about, and I think the FJC was what they had talked about, and this idea that we can be within the judiciary but be independent within the judiciary. That's the safest model for my money. But I definitely think that we have to remove at least portions of the defense aspect, and that's the CJ. And there's this talk about conflict. There's this inherent conflict between our office and the panel, and if we were helping to manage the panel, that conflict would be there. But we are the major clearinghouse for most every panel to come and talk about cases, get briefs, get filings, experience, and we have a conflict with almost every case they have. That's why they have it. Some of them they get when there is no conflict, but there are. But it is a tough question, and there's different points of view, but whatever the fix is, we have to get independence from a judiciary that sees us as spending too much money, maybe wasting money. And that's just not the case. And whatever the fix is, we have to get them out of the business of looking to see where they can save money from us. And that was a major push right around sequestration, and it was documented, that they thought that this was a really good area to save money. It's really not a good area to save money, and the cost is exponentially larger when you diminish the defense capacity, either at the federal defender or at the panel. And I would like everybody to know that when we say there's a two-tier system, it is not qualitative as far as the lawyers are concerned. The CJ panel is remarkable, but despite their efforts, they are severely handicapped when they are limited to spending less than a $10,000 mark or not on experts. They're not going to be able to do the job that my office can do. But I am not fearful.
Who do you think should seek funding from Congress? The AO? Who has your best interest? The AO or an independent entity to go ask for your funding? What's your opinion?
I think it's an independent group, and I think it was Delaware, the congressman from Delaware during sequestration had a hearing. I remember watching on TV. That was put together in part by Edson Bostic, talked to Congress, and they had a hearing on what the effects were. And it really developed quickly, and there's a lot of support there. And I do believe, despite the cynicism and the politics that may run rampant, that at the end of the day, when you see the outlay of money and the air that we put into this Constitution, I feel confident that that money will get there. We're talking less than, at this point, $1.5 billion. That's a couple bombs. We're not asking for hundreds of billions. We're not asking to make a huge dent, but we are bringing life to the Constitution. And I don't care how cynical the politicians are, I feel very confident. There's a lot of people who disagree with me, and they've been around doing it a lot longer, so I'm certainly, that's just my view, but I feel confident that we can get the funding that we need to get. And the benefit that we get of this independence is well worth that fight.
Judge Goldberg, we did a little informal calculation when we all got together earlier today and figured out that between Mr. Small and Mr. McNamara and I, we have over 70 years of experience, which is, I think, 490 dog years doing this kind of work. So I don't know if it's a caution that comes with age, but I think if I pulled up in front of the Thurgood Marshall building and saw all the DSO furniture out on the curb, I would have to go increase my anxiety meds pretty quick. I would not feel particularly sanguine about that. You know, when I talked about a time earlier where it seemed like things were going well, the Defender program was not at the associate directorate level then, but there was a Defender Services Committee. There is a Defender Services Committee, and that committee spent enough time with defenders over a period of years that they seemed, even if they may have come in hesitant at first or skeptical at first, they developed an appreciation of exactly what it is we do and how difficult it is and how much of it goes on out of sight of the court and the judges in their day-to-day work. And when that Defender Services Committee seemed to carry great weight in budgetary decisions within the AO, we didn't, I think, feel the same concern about independence that we may today. And I'm not suggesting that, oh, well, the best thing to do is to go back to that old model. I'm suggesting, well, this is an opportune time to tweak, to move incrementally in a direction that may draw on that experience and create a better paradigm within the administrative office. And once again, my suggestion would be to appreciate how that understanding of the defense process helped DSC and create an associate directorate with a focus on a staff that has direct experience in the criminal defense process, and have that associate directorate level have an equal seat at the table beneath the director, where hopefully it would carry greater weight, so that when the ask is made of Congress, the defenders would feel like we had our best shot.
So empower defender services, but continue to have the AO do your bidding in Congress. That's how I understand your position?
Yes, Your Honor.
Thank you.
I don't believe there's a consensus among defenders as to, what model we should seek to obtain in the future. I think that's because independence is an abstract principle, and we all are by profession risk managers. So for me, while I greatly cherish what independence I have and would like to see more independence for the program, the risk manager part of me is hesitant to commit to what people call full independence without seeing the nuts and bolts. And I think that's what's so difficult about this discussion. What I would like to see going forward, and I think the defenders are doing this among ourselves through research on our off time, and what I hope this committee does going forward, is explore different models that have, I assume, different levels of independence. And if you put those models out to the defenders, the risk manager and all of us, we can walk through different scenarios and see what the best model for us is for the next 3 years, for the next 5 years, for the next 10 years. Because what we don't know is whether, the problems we've had in the last 5 years, which have been significant, whether those problems are an anomaly or this is just how it's going to play out over the next few years. What causes me great concern and why I lead to independence, I was greatly troubled in reading the NACDL report, where I think a former chair of the DSC was quoted as saying that chair viewed or saw the judiciary's view as a competition for dollars between the judiciary and the defenders. I'm not naive enough to think that the defenders have a partnership, and certainly not an equal partnership with the judiciary. But to say that we're in competition for the same dollar, well, then when it comes to the question of who do you want to do your bidding, I don't want someone to do my bidding who's looking out for himself first, right? I would like a more equal partnership where everything's on the table. And again, if you're asking me now what my view is, that we have a transitory process to independence. That, I think it would be a mistake.
What is that? Could you spell that out in specifics?
Certainly. What I would be fearful of is 2 years from now saying, here you go, here's your independent agency. I think that may be a recipe for disaster. But I think, to use the tweak word, I think there can be a meaningful restructuring immediately, and we can see how that system plays out. Because the problem from my vantage point, and I have not been involved in these budgetary decisions for very long, but what I see is a lack of trust coming from the judiciary to the defender program. What I've heard for the few years that I've been involved is essentially that the defender program is a wasteful program, and that we have no regard for fiscal responsibility. And I think that was the one upshot that came out of the work measurement study that showed exactly the opposite. The work measurement showed that we do this work, and the CJA panel does this work at a tremendously high level, at a bargain price. So I don't see that part of it, that we need a watchdog because we're wasting money. But what I have noticed through the last few years is a complete lack of transparency. It seems that we're caught off guard by a number of decisions that the judiciary makes, and that we only find out after the fact. That's true with the demotion of DSO, I imagine. And I think it's true of a whole host of other issues. Like, so one of the recommendations I made, and this is not my own idea, this is an idea shared by many defenders. The Defender Services Committee, prior to that restructuring, which is another issue, was the primary funding source for our program. And why there's not a Defender participant on that committee it is astounding. So when you're talking about, oh, trust us, we'll do your bidding for you, and we don't have a seat at the table, well, I think the bare minimum that should come out of this process is that we get a seat at the table. And we see how a system with meaningful restructuring works for the next 2, 3 to 5 years, and then there's a reevaluation. Maybe then the cost benefit 5 years from now is that with restructuring, we have the best program we can have. But maybe it's not, and then maybe we move to a fully independent model. That would be sort of my viewpoint.
Mr. Small. Did you want to add anything, Mr.
Okay.
Small?
First of all, complete independence is a myth. We're talking about appropriated funds. And as long as there are appropriated funds, Congress is going to have something to say about that money. And I don't care who goes to Congress, whether there's review on the front end, we were talking about how can we solve this problem, whether there's review on the front end and say, well, you've only justified this much money, or whether there's review on the back end where it says, well, we saw what you did this past year, and we think it only warrants so much money for the next year. Somebody's going to be making those decisions, and it doesn't make any difference who goes and asks for the money. But perhaps it's depending upon whose ox is gored. If your ox hasn't been gored, you're perhaps quite happy with the things are in the present circumstances. South Carolina, I think, has been very blessed because the court system has stayed out of our business completely. And so we don't have that problem. But the people that have had it, it's certainly a different circumstance. So I'm with Mr. McNamara that goes along. I would like to see things restored because we were very proud of the fact that the Defender program had a hierarchy place in the system. And it doesn't anymore. And that makes all of us feel a little bit unwanted or like a second-class citizen or something of that nature. And so perhaps it's a feeling, maybe it's not warranted, but certainly I think I speak for all defenders to say we feel like we've been put down a little bit.
And also the way that it was instituted. Kate Clark was hired at the higher level, and soon after she took the job, or as she was taking the job, she was told that she was going to be demoted. And it came as a huge surprise to DSO and that shift. And I was actually working at DSO when it happened. It was extremely demoralizing to lose power that had been entrusted to us and that we had responsibly handled. And when you, on this overarching idea that the judiciary has said we have to have cost containment, and it was probably one of the reasons I suspect for the demotion, to have more control over that. It is very scary, but I agree with these gentlemen. It's incremental would be probably perfection. Take it as it goes. But to return the important independence of it, because it's just not a group, it's not some group that's doing it, it's the judiciary. And call it a tripod, call it a three-legged stool, call it whatever you want. It's just not a good idea to have one of those people or one of those groups with so much power over the other. It would not work if it was the judiciary having that power over the prosecutor, over the prosecutors. And there's no reason why it should work with as much power as they have now over the defense function. There has to be a pullback, and there has to be room for each of these groups to do what they need to do.
All right, we're going to move on to Dr. Rucker.
Thank you, Judge Cardone. I'd like to pick up on a couple of points that several of you have made. One of the concerns that I really have is the real inequity between the U.S. Attorney, your offices as federal defenders, and especially the panel attorneys. It seems to me there's a huge decrease in the amount of resources available as you go down that line. And I've heard some of you speak to that. So I would like for you to address that a little bit, particularly in terms of a model, if you will, sort of like what Mr. McNamara is talking about of what he does in his district. And think about perhaps that as a model that could be expanded with some independence from the judges, where you're doing a lot of, if I understand correctly, panel management. You're working with the panels, you're reviewing the vouchers, you have input on who's appointed to the panel, things of this nature. You're reviewing the vouchers, you work with the attorneys to do a lot of this work. So I'd like for you to think about that as a possible model, taking the judges, let's say, out of it. That you would have the money to look at the vouchers, and I'd like for you to talk a little bit about how much work this takes in your office right now and what it would take to expand that model. I'd like to know how much time this takes for you and your staff to do what you're doing now, and if we expanded that more, what you would anticipate it would take. I'd like to get some sense about the number of vouchers that you're reviewing per year, if you make cuts, and if you do so, if you talk with the attorneys about the cuts. Would this be a better model to get resources to the attorneys for experts so that we wouldn't have to go to the court? Because we've heard a lot of complaints about holdbacks, about cutting vouchers, about people not being paid more than $7,000 or $8,000 when they should be paid $20,000 or $30,000 or maybe much more than that. So I'd like for you, all of you, but let me start with Mr. McNamara, to give a little thought about that and see, is this something that might be reasonable for the defenders to do nationally?
Sure. I hope it would be, because the model has worked so well in our district, but it is time consuming. I probably spend a full day each week just writing these reasonableness reviews, and of course it causes me to work overtime to get them all in, sometimes on weekends. The judges expect 2 to 3 pages of a memo from me where I analyze everything they've done, particularly looking at travel, conference time with clients. We have a large district, 44 counties, and oftentimes the panel attorneys will turn in travel like 50 hours or 75 hours of just travel in one case. So I have to take all that apart, and if I don't have the answers, I have to go back to the panel attorney and ask them, you better justify this a little more because you may have a problem here. Now the
Mr. McNamara, can I
Yes,
clarify
ma'am.
something? Are you saying, how long have you been doing the voucher review?
I'm sorry,
How long have you been doing it?
Ever since I've been there for almost 16 years now.
Okay,
I've
and are you saying on every voucher you write one of those, even though some of it would, you have to do a review of every voucher in a written report?
The ones that go over the statutory maximum. Now, I review the ones under the stat max, but our panel administrator does the math and the technical part of it, and I just check off on it if it looks okay. But I added up, I think in my submission, this says like 135 vouchers in the last 3 years that I wrote. But if you go back 16 years, I've probably written 1,000 of them.
But it's only for the ones that go over the statutory
That's right.
max? Okay.
But that's the ones the judges are principally concerned about. Now, our panel administrator will look at it and do the math and the technical part of it and make sure they have all the documentation they need. And then she'll give it to me to write the reasonableness review. So, but mine is more time consuming than hers. But it's worked in our district, but I know an awful lot of federal defenders don't want that much work thrown on them. Park Small has a lawyer who is serving as his panel administrator, and she does this work. And I just think that it's necessary, if you're going to do it, to have a lawyer with experience as to what the panel attorneys are doing in their work, because we have to look to see if they've overbilled, overextended themselves, done something they shouldn't do, because that's what the judges look for. And it does result in our district with very little voucher cutting. Now, there was more voucher cutting back in the sequestration year or years there. But of late, I guess it's 97% of the vouchers will get paid. So, and I credit that to me supporting the panel attorneys. Now, I don't support everyone, and that's why I think the judges appreciate my view on that, because several of the younger panel attorneys in particular are ones that are known to, you drive. One panel attorney, as an example, made 20 trips from Raleigh to Wilmington, a 2.5-hour drive to see the client in a regular just drug case, and that was unnecessary, and I called him on it, and just the judge reduced his voucher. So, but I think all in all, it works. I hope I'm answering your question enough. So, now can I add one other thing in it? It hit me as you were starting to talk. Now, to be on an equal footing with the U.S. Attorney's Office, in our district, we are not. They get lawyers galore for the asking. They don't get their lawyer status, I mean the number of assistant U.S. attorneys based on caseload. So they end up with more prosecutors than we can get defense attorneys, and even if you match up the panel attorneys against them, they have more money than we can get. Now, we're supposed to be on an equal footing. They say we are salary-wise, but we're not on an equal footing when it comes to running the office. So that's just an aside that hit me as you started your question. And I know other defenders have thought about that, but I better let someone else speak.
Dr. Rucker, I'd love to speak to that. I think tomorrow one of our panel attorneys, Mark Jones, is going to testify before this committee. And before he was a panel attorney, he was an assistant United States attorney. So he will have, I think, a very informed perspective on this. But when I first became the federal defender, shortly after I became the federal defender, is when Frank Dunham became the federal defender in the Eastern District of Virginia. And he had been the U.S. attorney for the Eastern District of Virginia. And he was the first one to stand up beside me and be a co-timekeeping crank about why that is a good measure of how we should be funded. He recognized, as well as anybody could, that it is all in relation to the Department of Justice, what they are spending in that district. That is how we work. And to divorce that from the budgetary process did not make sense to him. It did not make sense to me. Now, I'm not suggesting that it should be dollar for dollar the same with defense attorneys, because as anyone would recognize, the U.S. attorneys don't represent a mentally ill client, unless you talk to certain folks in Oregon. And they have tremendous resources with multiple law enforcement agencies who are a phone call away. They rarely have to leave their desk to do their job until they go to court, whereas we have to go to a variety of facilities and deal with horribly mentally ill clients in many cases. And we don't have, while we may have investigators or in-house experts to some degree, we certainly don't have the resources that the U.S. Attorney has. Nonetheless, the budget, it always seems to me that Congress should be encouraged to understand that if they want to spend money on a prosecution, then they have to spend money on the defense, and that there's a correlation. And if the federal prosecutor is becoming increasingly a part of the criminal justice system, as it has been for the last 30 years, then there is going to be an increasing and corresponding cost, and that it shouldn't be that hard to come up with a reasonable ratio of what that defense cost should be. And if, in my fantasy of how we would ever get to independence, if we were to get there, if on the way there we began to make that connection and make Congress understand that, like them or hate them, the defenders are a necessary evil, and if you're going to spend the money on the prosecution, you have to spend the money on the defense. And you set that as a pattern of funding over a period of years or decades, then maybe somewhere in the sweet by and by, there could be complete independence. But I think it is incumbent to try and not separate what we do from the prosecution.
I've taught a lot about experts, and as I wrote in my statement, 100% of the cases handled by the U.S. Attorney's Office has experts. You have agents, lab technicians, FBI, I remember when I was in law school, we were being recruited by the FBI. They wanted agents to have law degrees. So the depth of experience and expertise that any U.S. attorney has at their fingertips, Quantico, I mean, it goes on, and we are reactive. We also, something that I learned recently, we're only given funding for what they say butts and seats. They don't give us X amount of dollars and hire as many or as little as you want. We have to show somebody sitting there before we get the funding for an employee. We can't be shifting it around. And a number of federal defenders, knowing that I was going to ask that the panel be shifted over to the federal defenders, wanted to shoot me. It's a lot of work. But that's what we do, is a lot of work. And I know that in Puerto Rico, they process somewhere between 110 and 150 vouchers, give or take, per month. Very busy district. I know that there's 4 people at the clerk's office who handle it. But if you're talking about what's cost effective, what could be better than having a federal defense function who understands federal defense to look at a voucher and quickly assess, is this travel ridiculous? Is this expert ridiculous? Is the time that you spent with the family unreasonable? And what did the case actually involve? It'd be a lot of work for us, and it's not work that I want to do necessarily, but I think we are the best people to do it, and I think that justice and the pride that we take in this system that's where it comes from, is doing this work. And unfortunately, I don't know of a group right now, unless we construct a new group, that can do it and save what we have and promote it.
Mr. Crusoe, you're in a high-volume district. What's your comments?
Yeah, so I am a proponent of moving both the overall case vouchering and the expert appointments and the vouchering of experts to either the Defender program or some combination of the Defender program with CJ involvement. So, because I don't think, to slightly disagree with Mr. Voss, I don't think the issue has ever been in this district or in other districts that people are making ridiculous requests. I think we face the other issue. I don't know whether CJ lawyers believe they have the resources to provide what is needed to the particular client. And like I said earlier, I think by removing those decisions from the judge who's presiding over the lawyer's case, I think there'll be a more fruitful back and forth with whomever is making those decisions, whether it's within the Defender office, although the Defender office would have to be staffed accordingly. This does involve a ton of work in addition to the work that we're already doing. And the conflicts have to be managed. Now, I think those conflicts can be managed within a Defender's office. Defenders do that now. But I would also be comfortable with a model that includes an independent administrator, a representative from the Federal Public Defender's Office, and a member of the local CJA committee. I think all those voices need to be heard. There's a value to someone having a background in criminal defense, but being independent. There's a value to having the public defender involved who has a significant amount of institutional knowledge. But there's also a value from having a CJA representative weigh in on that decision, because what is lost, I think, on the defender is how difficult it is to practice criminal defense as a solo practitioner under the CJA model. Now, the problem with the CJA aspect of it is, all our CJA representatives who do much of the administrative work, they're not compensated for that. So that's an issue in considering whether that's an appropriate model, would have to be factored in. But like, for example, in this district, we have a local CJ committee that has, I believe at latest count, 15 members. So if there could be a rotating CJ committee member that's involved in those decisions for a period of, say, 3 months, well, that's not a tremendous amount of work for that lawyer at that particular time, but I think it would give much value added to the process. And again, as I said before, I think through this process, there can be cost containment, especially with experts, with the gathering of institutional knowledge and bargaining power. And I would echo with what Mr. Voss said. I don't think anyone, again, is naive enough to believe that we're going to achieve parity from the United States with the United States Attorney's Office, even if you include the CJ panel lawyers in the equation. In this district, we do about 65% of the cases. We take ordinarily the first named defendant, so ordinarily that's the lead defendant, and we're expected to do that work, but that work costs a lot of money, and which we're more than willing to do. But with regard to managing the panel, we absolutely can do that given the resources.
Mr. Small? Well, our panel administrator is pretty much full-time because of all the work being done. So to increase that workload a little bit, to give more assistance to the panel would not be a problem, because we keep that particular position in really a separate part of the office, completely independent from the other lawyers, really doesn't have any interaction with the other lawyers. So we pretty much have erected a wall to protect everybody. And someone else talked about the success of getting vouchers approved. We are, I think, all but 2.4% of the requested money is approved district-wide, which is pretty good. And half of that is oftentimes mistakes in math or other things that change the calculus. But so I think that's a pretty good record.
I would just like to say, when I talked about ridiculous, I don't mean to say that I believe that the panel, I've never seen panels do work that I thought was just a waste of time. I think that if you're on the panel, you're not in it for the money, you're in it because you truly believe in that work, because no matter how you cut it, at the end of the day, the panel attorneys are doing a tremendous service at a discounted price. They know that. And you cannot be a panel attorney without having an unbelievable desire to work with those clients and to work within the criminal system. It's not something they do for the economics. There has to be more than that. And
All right, we're going to move on to Mr. McBride.
Thanks, Judge Cardone. And let me just join my colleagues in thanking the panel for your testimony this afternoon. It's immensely helpful. Just picking up on Mr. Small's comment to Dr. Rucker and Mr. McNamara's earlier comment on voucher cutting or voucher averaging, that's something that the committee has heard a lot about to date in our prior public hearings, in written submission from your colleagues around the country, your fellow brethren in the defense bar. Several of you have referenced the NACDL report, which talks about that. If I understood Mr. McNamara correctly, I believe you said that upwards of about 95% of vouchers are approved in your district. And I think, Mr. Small, you said it was a pretty high percentage in your district as well. One thing as a committee we've just been trying to nail down, it's been seemed a little elusive today, but it's trying to get hard data on voucher cutting and voucher averaging and how big of an issue it is in different districts. And to date, it's seemed largely anecdotal from CJA reps or defender reps. And that may be with good reason, because many defenders do not have a role in voucher approval, unlike Mr. McNamara. But a quick question for Mr. Caruso, Mr. Allen, Mr. Voss. Just curious, what is your sense of how big or small a problem of voucher cutting or voucher averaging, in your respective districts, and whether your basis of whatever you will say to that part of the question really is anecdotal, or whether there have been efforts in your district to try and get some of the data behind whatever your ballpark is. We'll start with Mr. Caruso.
I'll answer your question. I don't know. This is something that has been discussed frequently because I don't have a role in the vouchers. I have, sort of very sporadic contact with the vouchering process. I do hear anecdotal evidence and stories from CJA lawyers about voucher cuts. I've been contacted on a number of occasions by judges who received a voucher and want my take on the voucher, and then sometimes my assistance with interfacing with the CJA lawyer regarding the voucher. This is my sense of the issues in this district. There doesn't seem to be any issue with vouchers under or slightly over the statutory cap for relatively simple cases. There also don't seem to be issues with the mega cases, because the mega cases are budgeted up front. Everyone's on the same page with regard to the work that needs to be done and what's ultimately going to be paid out. Of course, case-specific things can happen from time to time. I think, again, based on my sort of informal knowledge, the issue occurs in the mid-range case that's a plea but has a fairly large bill, $40,000, $50,000, $60,000. Because I think what's happened in the past, and I think there was some discussion of this in Santa Fe, I think in the past judges could be fairly confident by looking at the docket sheet or recalling what happened in court to get a general sense of how complex the case was and what type of work went into the defense of the case. Because of the change in our practice, I don't think that's any longer the case. So for example, as you know, we have a high volume of fraud cases in this district, cases where a $100 million loss is seen as a normal and ordinary case. Well, those cases come with a great amount of discovery that has to be reviewed, even if there's not a trial, because, again, as you know, the primary determinant of the person's sentence is the loss figure. So you have to go through all those documents to get a handle on the loss figure. The U.S. Attorney's Office is in a much better position because their case agent is either a lawyer or an accountant. So you're well behind the curve. And you need to do a substantial amount of work that's unknown to the district court judge, even to have an intelligent conversation with the prosecutor. And sometimes you can convince the AUSA, sometimes you can't. Now, when you go to court for sentencing and there's litigation about the loss figure, the district court is then more aware of what type of work went into the case. But I think there's a particular issue with the plea, and you're able to convince the AUSA about the loss figure through, hundreds of hours of research, not of all you've billed for. Because you go to court and it's either in the plea agreement or there's a stipulation at sentencing that we've agreed. Because then the judge has no idea, all the work that went into convincing the prosecutor. If you're able to convince the prosecutor, then you have to get the prosecutor to convince the probation officer to support that figure in the PSI. So I think those are the areas where district courts struggle with a change of plea, that there's not much pretrial motion practice, and there's a relatively high bill because of document review. And I think that's where either an independent administrator or an FPD or CJA representative, I think we can really work through those issues better than the court at this point.
Mr. Mr. Allen or Mr. Boss, any thoughts?
I think it is a highly unusual occurrence, voucher cutting in the Middle District of North Carolina, which is a wonderful thing, but since I don't deal with the vouchers directly, I might not know in some cases. I spoke with our CJA panel rep about this, and she was aware of one instance where it was a multi-defendant case and one voucher came in significantly higher than the other vouchers in the case, and that the voucher was cut. And what was troubling, as I heard it related, was that there was no hearing about the voucher cut to determine what was unusual about this particular defendant that would cause him to require so much more attorney time. But that is the only instance I'm aware of.
I was told by someone who works at the circuit level that they rarely, if ever, see a voucher that's gone above the limit where it's going to the circuit that hasn't previously been cut. I see voucher cutting when the panel comes to me with an issue and they want me to look at it, and they know that I worked at DSO, how do they take care of it? So I see a lot of averaging. What troubles me is not only do I see averaging within a large indictment, I see averaging across cases. I saw a case recently where the case had a lengthy suppression hearing. The government insisted they would not give a plea agreement that preserved the issue. They went almost to trial. Finally, the government backed down, so the attorney prepared for trial. There was around a $20,000 voucher, and the judge just looked at it with no explanation and said, this is a run-of-the-mill case. I'm only giving $7,000. It is not extraordinary in our circuit, which means that it's happening to a degree where it's become common practice, not common, but it's accepted practice. And my fear is that we will devolve into this system where there's a known number for a certain type of case, and then all the defendants become, or our clients become the same person, despite mental illness, despite family issues, mitigation. You know, Booker is a fantastic case for us, but Booker has brought a dynamic into this that the court needs to hear about all these things. And so what is average for one case is not average for the other. But it is something that is complained to continuously to myself. And I recently interviewed someone from the panel to work for us, and I said, well, why is your average case X amount of dollars then? Because they were talking about how, they said, that's what we have to bill, and if we bill more, there will be a delay, and the economic pressure on not to wait long periods of time for it to move up the chain and be cut back and forth creates a self-imposed, well, it's imposed upon them. So is it our biggest problem? Maybe not, but it is a problem. And it just has to be done a couple times, in my estimation, for it to be a big problem. And it seems that they call them outliers in our district. And again, it is anecdotal, but there's enough anecdotes out there for me to really think it's a problem, and it's an accepted practice by the court in our district. And if it's accepted, it means that it's been done enough not to raise concerns.
Thank you.
All right, I'm going to go ahead and let any committee member ask questions. I would ask, since we have a number of you, that if you have a question, you direct it and ask your question, and then get the answer, and then we'll move on to another committee member. And if you have a question, kind of raise your hand. I'll try to recognize you. Who has? Any of the committee members have a question you want to ask? Judge Fisher.
Several of you have mentioned the volume of discovery that's provided by the U.S. Attorney's Office and multi-defendant cases and extraordinary numbers. My district, Central California, has both of those issues. How do you see our committee assisting with that issue at all?
You know, that's a difficult question, and one I've thought about quite a bit. I mean, I think the federal rules of criminal procedure have to be amended to recognize that we're more like civil cases now than we've been like criminal cases in the past. In fact, we just had a lawyer retire from our office who's one of the original lawyers from 1974, and I wanted to pull out his first case file that's still in storage, which is another cost issue I have to address, right? And it's, it's a complete case file, and it must be, 20 pages long. So I think that there has to be, a serious attempt to look at the rules of criminal procedure, Rule 16, and recognize that criminal cases are more like civil cases at this point, and there have to be, fuller discovery protections for our clients. We've actually come to a point here in this district where the process is quite haphazard. So we may have a case where you just get a document dump. So you're getting terabytes of information with no clue as to what that discovery contains. We have other cases where prosecutors will provide a skeletal index. We have other cases where the prosecutors provide a full index and will sit down and talk with you and walk you through everything that's in the 1,000 PDFs that's contained in this one particular folder. But unless there is a uniform standard, especially in the area of electronic discovery, I don't know if there's much we can do except bargain on a district-by-district and case-by-case basis for, a better outcome.
Anyone else have any questions?
Could I follow up on that?
Sure.
Follow up on that, if I could, Mr. Crusoe. You've dealt with some really huge cases. You talked about 3 terabytes and more, things like that. Is it reasonable that the defender offices, because of the resources you have in working with those in these big multi-defendant cases and big e-discovery cases, could work as a discovery coordinator to work with the panel attorneys on this as well? Even if I know sometimes there's conflicts, but could you set up some kind of a wall or something to do that?
I think not under our current structure. I highlighted some of the cases in my written testimony, but we have others. Mr. McBride knows from where he practices. I didn't even mention the national security cases that we've had, where we get that same volume of discovery, but the lawyer and the investigator have to go to a SCIF where they have no contact with the outside world. Under our current structure, with our current level of resources, I don't think we could do that, because when I assign those cases, it's really like moving chess pieces around a board. So the lawyer who handled the 3 terabyte case, she worked with another lawyer, and so her caseload was reduced dramatically. Her second chair didn't really have a reduced caseload until shortly before trial. So having that same lawyer still have other cases within the office, trying to defend that case and acting as a discovery coordinator, I think would be an impossible task. But I think that is a good model to help the district, that there be some avenue for a CJ discovery coordinator, because I think there would be tremendous economies of scale. That CJ coordinator, who would have no relationship to any particular defendant in the case, would be hopefully conflict-free or could manage those conflicts. And I think, that would have, 2 impacts, right? The discovery could be processed in a more beneficial manner to the lawyers, and I think it would be a cost savings mechanism as well.
There's already a group through DSO, and I think they work under the training division. There's 3 full-time people. They're in Oakland, and I have directed many CJ attorneys, when they get these large cases, and they will work very closely, almost as experts, non-billing. So that's something that I think it'd be a great idea. It began small. It's still pretty small, but They have been fantastic. And I know that they have some agreements already with the U.S. Attorney's Office on the way in which electronic discovery should be provided. But it's very difficult to have that in-house expertise for us to do it. But there is a national group through DSO who does it.
Anyone else? Ruben? Judge Prado, go ahead.
Okay. Some of you aren't involved in the vouchers, but I'm just wondering, maybe in defense of some of my colleagues, I don't know. How much of the voucher cutting is due to the lawyer's inexperience in filling out the voucher or not knowing how to make a proper request for an expert, that maybe the cut was justified or they didn't explain themselves properly enough, whereas if they would have had more training or experience in how to fill out the voucher or how to make the request, maybe it would have been approved. I mean, I guess it works both ways. A lot of it is the judges cut it just because they think it's too much, and they don't offer an explanation. And then so you're stuck with, I don't know why I got cut. But would education of CJA lawyers on how to fill a voucher or how to make a request for an expert, would that help the situation?
Judge Prado, I think it would if they would listen. Now, we try to convince them that they need to fill out their requests better than they do. And you're right, sometimes they're denied because the judge looks at it and then I see it later and say, no wonder the judge denied it. But it's not everything. Some of it is further problems than that, but some of it is definitely from that. But we try to put that into our training, and we give sometimes 3 of these large training sessions per year, and I send out emails all the time trying to educate the panel attorneys, and most of them have come around that do better, but some of the younger lawyers, they're the ones getting cut for sure.
Well, in South Carolina, we give the panel attorney every chance. I mean, when the administrator gets the voucher, if she doesn't like the way it looks or it's out of whack in some way, she calls the attorney, says, look, we need to get this thing in shape before it goes to the judge. So we give every opportunity, and sometimes we'll have 2 or 3 conversations with the panel attorney, saying, look, you need to do more, you need to explain this, explain why you did that, and it'll be okay. And it is. So, I mean, that's our solution as to how we get the panel attorneys in line to get what they're entitled to get.
Does the administrator work for your office?
Yes.
Okay.
Ruben?
I had 2 questions. One is really quick, just for Michael. You know, the original idea behind these coordinating discovery attorneys was that they would actually be appointed in individual cases to manage discovery. And the Southern District's got a huge volume of these cases. Are you seeing that ever? Are there ever appointments of the coordinating
You know, I've seen that process used very infrequently. You know, the one that comes to mind is we had a very significant healthcare fraud case where Judge Seitz appointed, I think Russell Aoki, I think he was appointed the discovery coordinator, very, very infrequently.
Did you get any feedback on how it worked in that case?
I think everyone was satisfied by that process, the CJ lawyers and the judge. You know, what the CJ lawyers, and I think the judges, fear is uncertainty. And by having a discovery coordinator come in, you know, at the beginning of the case and manage that process is very helpful, because, you know, you also have to understand, you know this, and most of the committee members know this, is that the technology and the delivery of the discovery varies from agency to agency. So the FBI and the DEA and Homeland Security and the IRS, they all use different formats. And if you're a CJ lawyer on the panel who receives between 4 or 6 cases a year, might not have had a case with the IRS for 5 years. So I think the discovery coordinator is very important. I also think a budgeting attorney that deals with cost issues on the front end rather than dealing with them all on the back end would also be extremely useful.
The other question I had really goes back to this independence question that we were discussing earlier, because I'm trying you know, as a member of the committee who's a defender and who I think should represent defender views to better understand the community. And I'd ask everyone to engage in a thought experiment for the moment and imagine that defenders were like the Federal Reserve and we could print our own money. Would anyone continue to support judicial involvement in the program under those circumstances? And if so, can you tell me why?
I don't think it would last. You could start out like that, but it wouldn't last because sooner or later Congress would say no.
Okay, well, I'm asking you to imagine it possible for a moment. So, is there anything other than money that would prevent you from supporting that independence?
I would say,
or is there any, more to the point, is there a reason you want continued judicial involvement other than money? That's really
Ruben, I can't hear you very well, and I'm sure.
Is there a reason other than the fear of loss of funding that would lead you to support continued judicial involvement in the management of the program?
I would say no. I'm sorry, I would say no. And my confidence in the way in which the defenders have handled their money came out of the work study, but judges have a tremendous amount of control over us in the courtroom. And that's where it should stay. Outside of the courtroom, this kind of this idea that you can take hats off and put them on, I don't understand it. Maybe that's my limitation, but I don't see, there's a tremendous amount of control over us in the courtroom, and that's where it should remain.
Should judges have any input whatsoever in the makeup of the CJA panel?
Absolutely, absolutely. I think that judges should have, I mean, there's a committee that we have in Puerto Rico where they have to come in, the panel members, they have to initially be interviewed and then they have to be approved, and we have a magistrate judge and the chief judge is there, and you know, their involvement is critical because they understand what it's like to look at these attorneys from a judicial point, which is critical. But I think that they should have a voice, as CJA rep is there. We have people on the panel. There's actually someone on our panel who's not even on the CJA. But yes, they should be involved, but not in the way that we're doing our defense work.
Ruben, could I answer that? Because I guess I have a unique district that, putting money aside, I still don't see problems with judges' involvement because we get along so well together. I mean, they respect me, I respect them, but it may be very unusual from what happens in a lot of districts.
All right, we have time for two more questions. I'm going to have Chip and I think Professor Gold. So, Chip.
First, this is for Mr. McNamara. I think one of the hesitations that defenders might have to taking on more of a role like yours is the incredible amount of time that you spend doing it. And I'm curious, if you were the final decision maker, meaning that you weren't preparing these 3 or 4 page memorandums to go to somebody else to make the decision, and it's sort of the buck stopped with you, how do you think that would affect the time that you spend? Would it be less, more, or about the same?
Probably less. Chip, if I had the ultimate decision that the judges have, I guess I wouldn't have to write myself all these reviews. I just look at it and say, this is okay, this is not okay. So I think that would make a big difference.
So from a resource standpoint, if you sort of cut yourself out as the middleman and made yourself the final person, then that wouldn't be such an extreme resource burden.
Maybe not, yeah. And I realize it's a heck of a lot of work, and a lot of the defenders don't want that work, but I've taken, you know, I guess I've gotten used to it over all these years, so I've taken pleasure in being able to help the judges with my view of, again, my 50 years of service. I kind of can look at a case pretty easily and say whether it's appropriate or not appropriate. It just takes longer to write the memo.
Professor Gold?
All right, well, I'll try to do this without a microphone. Can you all hear me?
Yes, sir.
So I know one of the things that the committee is interested in is not simply voucher cutting, but the extent to which attorneys are even putting the effort in or seeking experts in the first place. And I have data here from your districts of panel panel cases in fiscal year 15. And if we look at the percentage of cases in which panel lawyers are seeking experts across your 5 districts, the average is 19% of cases. The low, and I'm not going to say which district it is, but the low is 1% of cases with the average expert payment being $19. So I guess I have 2 questions to you all, and I'm sorry to be the last one to ask, but number 1, can you explain it? And 2, what does this say about what I hear to be a fairly broad conclusion from all of you, that representation is of high quality in your districts? Does this challenge that or not?
Well, let me go first then. I hear from Defender Services that the panel attorneys are not asking for enough experts, and I do preach that to them frequently. Now, yeah, I hope I'm not the 1% one, but if they're not asking for them, that's their problem. But 19% is still too low. And I don't know, I think in my district they're reluctant to do it because they think they'll get turned down. So I don't know what some of the other thoughts are.
I suspect ours is around 5%.
Actually, you jumped up in FY 15 to 11%, but you were correct. Previously, you were at 5%.
Okay. A lot of it's education, and a lot of it is, you know, if, as someone pointed out, if you get a lot of no's and told that it's not necessary, you're asking for those experts is time-consuming, and it sometimes is back and forth a number of times before you get your final no. And so when they're already being cut at other areas, that, you know, I don't know about everybody else's economy, but ours has hit rock bottom and now we're digging in Puerto Rico. People are making really tough decisions, and if you can't get an expert and you haven't been able to get experts, you may be reluctant to again ask. But again, we don't have a problem with experts. The U.S. Attorney's Office certainly doesn't have a problem with experts, but a lot of people are having problems with experts, and I don't care if it's 1% or 19%. It's a problem.
Judge, can I follow up on that?
Hold on. I think Mr. Allen wanted to say something, and then Mr.
That's okay,
Okay,
Judge. Thank you.
Go ahead.
We heard at the Santa Fe hearings, and we've heard from some other lawyers that, or CJA lawyers, that one of the issues for them is to try and keep the price, or the cost, if you will, of the case lower. And that when you use an expert, obviously the price of the case goes up. And folks have indicated some reluctance to do that because then they perhaps wouldn't get paid, their voucher would get reduced. Does anyone think that that's an issue, or has anyone heard anything in their district that CJA lawyers are concerned about that? And the second part of that is any concern about the cost of the voucher and self-reducing the voucher. I know in the 2 districts, Mr. Small's district, Mr. McNamara's district, you've indicated that the vouchers are being processed and to a great percentage being paid. I'm asking whether or not you know of any indication that the attorneys are reducing the vouchers themselves, perhaps below the statutory cap, statutory maximum, in an effort to make sure the vouchers get paid.
They do that frequently in my district to stay under the cap, because then they can get paid quicker and they don't have to risk any reduction. I do know that. I'm not sure about.
Well, we've got a rule that if it's only $200 over the cap, we'll call the lawyer and say, look, we're going to have to go to the circuit with this one. Do you just want to voluntarily take a $200 cut and get your money now, or do you want to wait? It's not as a threat, but the process of going to the circuit just takes a lot of time. And oftentimes, they would prefer to go ahead and just take the cap rather than wait on the money. But it's not used as a threat at all. It's just a courtesy.
Can I ask, I know I said we're dealing with, now I have a concern because the cap for experts is $2,700, or it goes to the circuit, right? So how is that, I mean, you guys all have experts at your fingertips. How do you see that cap? Should there be a cap? How high should the cap be? Should it, I mean, you're in the process of beginning a case, and you have to somehow ask for this cap to be raised. Is that a realistic cap at all? And if not, what would be?
I think, Judge, that Chief Judge Osteen from our district, that was one of the specific things that he addressed in his letter to the court that he saw from the bench, and he certainly has even more experience watching this than I do. He saw that there was a problem with the cap and getting the quality of mental health expert services that the court feels like the case deserves. And that when the bench recognizes that, I assure you that the panel feels it as well.
I agree on that. I think the cap definitely needs to be raised for experts because it's just getting more expensive these days.
I agree. Under the current cap, I don't think you can hire a mental health expert, for that aspect of the case without busting that cap. So I think the cap should be raised.
Well, one of our themes is trust, and raising the cap, it just places the trust where it ought to be, and that is in the lawyer.
Thank you. All right, we're going to go ahead and break on this panel. Again, on behalf of all of the committee, I want to thank you all. I don't know, we're going to be writing the report. If we need any follow-up, we may reach out to you. But in the meantime, thank you very much for your time. We're going to take a short recess. We're going to resume at 3:30 with panel 2.